To help better understand what is a complicated legal issue in this decision, we want to bring in Professor Carolyn Shapiro of Chicago-Kent College of Law.
She is the founder and co-director of the school's Institute on the Supreme Court. Professor, what do the 6 justices in the majority say is the legal underpinning for their decision?
Well, what they say is, and this is really 5 of them say this, just the Chief Justice's opinion as a concurrence is a little different, but the 5 justices who all joined Justice Alito say the Constitution doesn't say anything about abortion. There's no abortion protected in our history and tradition. Therefore, it was a mistake to recognize abortion as a right, and we're not going to continue to recognize those precedents. It takes them a very long time, many pages to say this, but that's the basic structure of the argument. They don't really engage with arguments like the ways in which autonomy, bodily autonomy, privacy, precedents in those areas lead to recognizing a woman's right to control whether or not she carries a pregnancy to term. Other than to say, well, those are different, they don't involve fetal life.
Professor, I'd love to know from you, how much weight should we be giving Justice Clarence Thomas's statement in his concurrence that he wrote out that contraception and same-sex marriage should also be revisited?
Well, I think we should be very concerned about that. The majority tries to say, well, don't worry about that. We're not saying anything about that. None of those precedents have anything to do with fetal life, and fetal life is what sets abortion apart. But I don't take a lot of comfort in that, because the rest of the analysis that Justice Alito lays out in that majority opinion would call those precedents into question as well. Justice Thomas, to be fair, does not argue necessarily that those precedents have to be completely thrown out, but he wants to start from scratch. He says the Due Process Clause isn't the place to locate those rights, it's the Privileges and Immunities Clause, and what that means, nobody really knows. It would be, at best, extremely disruptive and lead to tremendous uncertainty were the court to follow that lead, and undoubtedly there are going to be plenty of litigants who try to get the court to do that.
Professor Shapiro, thank you so much.